Let's start with the idea of customary international law. What is customary international law? Customary international law is a body of commonly accepted rules of conduct, things that states have done consistently and over a period of time. And nations have followed these rules not simply out of politeness or convenience, but because they believe them to be binding obligations. The question, of course, of where does custom derive from, we need to see many states, maybe a majority of states, or certainly we look to see which of the particularly great powers engage in the practice, and states engage in the practice out of a sense of legal obligation, rather than, as I said, custom or habit or convenience or morality. They believe it to be the law. Now, there are two elements to customary international law. There must be a general practice, and that practice must be accepted as the law, as a binding legal obligation. Now, there are a number of issues that arise with the idea of customary international law. The biggest problem is that these laws, these international customs, are norms that have become pervasive internationally, but they are norms that a country need not even consent to in order to be bound. So generally, sovereign nations must agree to be bound by a particular treaty or by a legal norm. But when it comes to customary international law, this is law that is imposed on a country regardless of whether it has consented to the law or not. If a practice is widespread, if it's large enough, then according to the rule of customary international law, that practice can constitute a legal binding obligation even for those states that don't have that practice, that do not rely on that. So this is the biggest area of concern with customary international law, is that it binds countries even without their consent. And in fact, one could argue that it makes treaties much less important, because it doesn't matter if a country doesn't sign a treaty if that treaty now becomes the law. Now, there are other issues with the idea of the application of customary international law, starting with questions like how many states have to act in a certain way. A majority of states? A large minority of states? How many states have to act in a certain way for it to become customary? And when we talk about practice, is that based on multiple times this has happened? Or could a single act constitute a practice that would lead to the application of customary international law? And we said it has to be done over a long-standing period, but what is that period? Is it weeks, months, years, centuries? We don't know. Is the practice of some states more important than that of others? At what point does a state that acts differently from the custom, from the norm, at what point does that become a violation of the law? And finally, there is this paradox of a state has to believe that a rule is legally binding before it actually becomes the law. So if we say that general practice accepted as law, that means that it doesn't become the law until we already think it's the law. And there's sort of a paradoxical concept there. Now the most well-known case is a case called the Paquet-Habana, and I have a link to the Wikipedia page describing this case on Canvas. And this case arose out of a question of, should we apply international law in the United States, and how do we determine what is international law. Now, this case came out of a dispute that occurred as a result of the Spanish-American War in the latter years of the 19th century. Spain and the United States went to war in large part driven by the United States' desire to remove Spain from the Caribbean, from the United States' desire for Cuba and access to Cuba. And so this was the foundation of the war. Immediately after declaring war, one of the first things the United States did was they created a blockade around Cuba to stop ships from leaving and to prevent ships from coming back. Now, at the time the blockade was enacted, there were a number of Cuban fishing vessels out on the water fishing for food to bring back to Cuba. Now, in this era of naval actions, we followed what was called the prize system. And the way the prize system worked was that if a naval vessel seized another vessel, an enemy vessel, then everyone on board that vessel would get a share of the value of the captive vessel. And the prize system had been utilized throughout the 19th century, and much of the violence of the 19th century, much of the wars that were fought, were oftentimes based on economic needs, that if we go take those ships, then it becomes a source of income for everyone on board the ship. And so at this time, the United States followed the rule of prizes, the prize system. Now, the question is, are fishing vessels legitimate prizes that can be captured? And what happened was the ships that are out at sea, as they return, a naval vessel seizes two of the ships, the Paquette Habana as well as a ship called the Lola, and they take the vessels and they sell them, and they take the money. Part of it goes to the United States, part of it goes to the crews of the ships. Now, following the war, the owners of the vessels, the original owners of the vessels, sued the United States in federal court in the United States, arguing that fishing vessels were not legitimate prizes of war. And so the court had to first of all determine what is the rule about prizes. And they looked to see what is the custom. And it turns out that most of the countries they looked at, and there was only 8 countries, of those countries, most exempted fishing vessels from the prize system, meaning this vessel is composed of people going out working not in a military sense, and they're not gathering fish to use for military purposes, but instead they're simply to feed people. And so the court found that the capture of fishing vessels as a prize of war violated customary international law, that there was a custom in place that fishing vessels should not be interfered with during wartime. Now, the second thing that the Supreme Court had to look at is, now that we've determined this is international law, does international law play a role in a United States court? And what the Supreme Court held is that international law is integrated with U.S. law. It is a part of U.S. law. And therefore, these legal principles, these customary international legal principles, can be applied even in a United States court of law. So these are the two big takeaways from this case of the Paquette Habana. And the first is customary international law, custom can become a binding law. And the second principle, international law is part of United States law and can be adjudicated by a United States court.